Maharashtra Police. He has also worked with ISRO, Zydus and Tata Consultancy. We have with us the principal discussant, Advocate Pawan Trivedi. Advocate Trivedi is a practicing advocate at the High Court of Gujarat. Before we start with the presentations, I would just like to brief you about the guidelines of the session. Each session of the colloquium shall be of 1.5 to 3 hours respectively as per the program schedule. Each panel shall comprise of 2 experts, 1 chair and 1 principal discussant. The Q&A session, both online and offline, shall be conducted at the end of each presentation. The total time allotted for the presentations is 10 minutes. The presenters are requested to stick to their allotted time. Kindly note that the level of presenters shall consist of academicians, industry professionals, lawyers, researchers and students. The PowerPoint presentation should be of maximum 5 to 6 slides. Kindly carry a hard copy of your paper for reference or to avoid last minute hassle. Extension of time shall be dependent upon the discretion of the chair. Now we invite Mr. Amol Deshmukh to kindly address the gathering and the participants who have joined us online.
Honorable Vice Chancellor, Dr. OK sir, honorable guest, it was a great pleasure to participate in National Symposium on Criminal Procedure and Identification. I am happy here to be a part of this wonderful event. As a forensic expert, I am working on Criminal Procedure Identification Bill. So initially, when this Criminal Identification Act was made in 1920, before that also a lot many things were involved. So initially,
is anyone's vehicle number MH03BH 9089 parked somewhere?
Done? Okay. Yes, so basically criminal identification bill which we see today, which ask about to give lot of details, whether it is related with details of your biometric identification details, biomarkers and other behavioral details. But if you see at the beginning, like how the law enforcement agencies or how the people who are into police, how they used to identify a criminal, what was the initial thing? There was no scientific equipments, there was no scientific tools available. So how police might be identifying a criminal? Like for example, if a criminal who has broke the prison and escaped from the prison, now how someone is going to identify that criminal? That time there were no photographs. Photographs invented in 18th century. But what was before that? How they used to do? What was the machinery or what was the technique available that? So we will see that initially when there was nothing, so there was a system it is used to call as portal parley system, which was given by Alfonso Bertillon, who was a European scientist who had also given a system called as Bertinology. So where we used to do different body measurements and all. So now this system is abolished after fingerprint came into existence, but still that technique was practiced in many part of the Europe. Like initially, what the identification parade used to be like that. So initially, like any suspect or any person who got convicted, every police person who was into prison will come and see him from all the angles and try to memorize his face. And then they used to see it from all the angles, and that was the only way to identify, because that time there were no photographs, nothing, no techniques was available. And then they used to see that criminal, they will make him sit at the center and all police will sit around him and everyone will observe his minute facial details, like how is his eyes, nose and ear from all the sides, because you don't know when you are chasing him or when you are running to catch him, you don't know from which side you will see him. So that was the technique. But the invention of photography was a big breakthrough in criminal identification. So as photography got invented, police and law enforcement agencies was the first people to start using them for their making a criminal record. And if you see the Prisoners Identification Act, it has only 3 things in 1920 they used to do. They used to take fingerprints, they used to take footprints and photographs. Okay, so the photograph, when photography got invented, it was a big help to the law enforcement people, and then they started taking photographs of the criminal. You must have seen in movies, like whenever a criminal is caught, the police first they take photography from all angles, like front angle, side angle and all. So why they want to do so? They want to maintain a record, wanted to record for the identification. With time and all, then they also find that photography has also limitations and all. We cannot rely only on photography, because when like a person wants to disguise, then he will be having a beard and all, then it becomes difficult to compare with a photo. And then they started adopting a system, it is called as verticalized system. Means what? They started taking body measurements. So you must have seen when or in some movies you must have seen like they are taking all the measurements, different height and body measurements. But what happened, this system was quite successful, because after an age your height doesn't grow, body parameter get fixed, they doesn't change. Okay, so this Alfonso Bertillon, what he did, he found out if this can be a very good technique for the criminal identification and all. And then what happened, there was a situation and there was a case, it is called as Willie West case. So these Willie and William were 2 brothers, and they were genetic twins. And their all feature, appearance and body height, body measurement were exactly same. One was notorious and another was innocent. And this notorious has committed some heinous crime, and he was put into jail. And one day he break the prison and run away. And what happened? Police caught this another innocent fellow. जैसे हम लोग movie में होता ना, Sita and Geeta. Similar story. It happens into reality. And they put into a bar. That time there was no digital media, nothing to verify, nothing was there. He was in jail for several years. And one day they caught this another chap who was actual criminal. And then what happened? And then they come to realize that, oh, this technique is having some fault. And then what happened? They started looking for alternatives. Then what happened in India? That time Henry was there. So he was done lot of work related to fingerprints and all. So in 1902 there was a commission called Fraser Commission who had a conference in United Kingdom in London. That time they said that fingerprint is much better than what technique we are using for body measurements and identification, and then fingerprint was used. And then now today every country is using fingerprinting for criminal identification. But with time, if you see, so in India, 1897 first laboratory fingerprint bureau was established in Calcutta and all. But today also, if you see, fingerprint is the only valid technique which is used universally. But then what happened? Then we discovered DNA is also a way to identify. Then we have identified like voice is also a way for identification of a person. And then similarly what happened after 102 years, we have realized that there are other techniques also which can also give addition for criminal identification. So then in this bill we have added 3 features. One is a biometric identification which includes fingerprints, palm prints, iris scan, retinal scan was included into this. Second, we included biological markers like seminal samples, blood, saliva. Those are important in a case of sexual assault and rape. Okay. And third is the behavioral attribute like handwriting, signature, your behavioral profile. So this will give a better idea on this. Okay. So this was from my side. We'll start with the sessions. Thank you.
Thank you so much, sir. So we will start with the presentations. The first presenter is Ayushman Tripathi.
thank you so much. I would like to thank you and the organizers for such a lovely opportunity to speak on this matter and organizing such a great event. And on that note, I would like to, without wasting any time, I'd like to jump straight on my presentation, that is on the criminal identification bill. Before I start explaining and forward my view on what I believe the criminal identification bill is portraying and representing, I would like to begin with what I recently came across, the theory of pervasive incentive. The theory of, I think I'm mispronouncing the name, it's a slightly uncommon word to I've come across. So otherwise the theory is known as the Cobra effect. What this theory basically means is, when Britishers came to India, they came across a huge problem of cobras, and the population of cobras was really high in India. And to avoid that problem, and because it was a matter of safety, what they did was that they announced that anybody who brings a dead cobra will be rewarded with a specific amount, and will be rewarded with a price. And what that eventually led to is that people started capturing cobra, breeding them, and selling their bodies to the British government. What this theory represents is that the problem to a solution in itself becomes the problem, and this is exactly what I believe the problem with the criminal identification bill is. Moving forward with the introduction now. Is not working? Okay, it's fine. So moving forward with the introduction, I'd like to say that the Criminal Identification Act is a crucial legislation that helps identify criminals through the use of biometric technology. Although there are certain complications with the law, it is a far-reaching legal and ethical. There are many far-reaching legal and ethical implications with the legislation that require careful analysis and discussion. So moving forward with the legal perspective, I'd like to discuss that the nature of the field of law is that it is extremely precise and accurate in nature. Now, to leave any room for ambiguity is a problem, or is a room for potential violation of privacy and security. The ambiguous nature of the law makes this act in itself very problematic. The Criminal Identification Act has been subject of intense scrutiny by the judiciary. The Supreme Court of India, in a landmark case of Puttaswamy versus Union of India, declared that the right of privacy as a fundamental right under the Constitution of India. The right is closely linked to the use of biometric technology and the Criminal Identification Act. So, as I started talking about ambiguity, I would like to point out that there are various words and phrases that are used in the legislation that are in itself very ambiguous in nature and can be misinterpreted by various readers, and that is, again, as I said, the nature of the law is extremely precise, and to be accurate can lead to multiple issues and multiple problems. For example, words like biological samples, that can lead to issues of mass surveillance. And there are various other words that are defined in this legislation that still require a more comprehensive definition. Moving forward with the ethical concerns that I've mentioned in the paper as well, that from an ethical perspective, I believe that whenever the question of ethics is involved and we're moving forward to the discussion of ethics, the point becomes not of the legislation itself, that how the data is collected, stored, and moved between certain individuals and certain bodies. In discussion of ethics, the matter becomes of trust. That if you are forwarding the data towards the government, and if this issue was individual in nature and the legislation was existing in a vacuum, this wouldn't be a point of discussion. But there has been multiple legislation by the government and multiple attempts by the government that leads to this idea that the government is again and again trying to move forward in collection, trying to collect the data that we have. Now, the Act allows for collection of sensitive personal data information such as fingerprints and iris scans, which can be used for other purposes beyond criminal identification. The potential for the misuse of the data can result in serious violation of an individual's privacy and other rights. So moving forward with the Criminal Identification Act, the Act also raises question about fairness of criminal identification procedure. Now the data, for example, the data collected through the Criminal Identification Act can be the same set of data that is used to design multiple AIs leading to facial technology, developments in facial technology, and that data in itself, if it's not collected properly, will eventually lead to falsified assumptions by the artificial intelligence. So moreover, as I said about the use of biometric technology, can result in false positive, leading to wrongful convictions. The lack of transparency in the collection and use of biometric data can also lead to discrimination against certain communities. In conclusion, I'd like to wrap up my presentation now. The criminal identification in India has a far-reaching legal and ethical implication that require careful consideration, and although the act, I believe, can be an extremely useful act, the question that I believe in more the ethical direction, the question becomes of trust and how much we are relying on our government and how much we are trusting the lawmakers of the country, because the question in terms of legislation is extremely simple, that the data is sensitive in nature. The transparency of the procedure needs to be there. Besides all the recommendations pointed out in the PowerPoint presentations, I believe that the issue of criminal identification in terms of percentage, I'd say it's a 70% dispute of ethics and relying on the government, or the data storing authority, rather than the problem in the legislation itself. With that, I'd like to wrap up my presentation. Thank you.
Okay, what is the alternative in case if you want to do any reforms specifically related with the data management?
Sure, sir. Well, in terms of data management, I believe the key to any successful legislation is policy design. So I'd like to also state an example, sir. For example, for organ donation, the leading country is Spain with the highest number of organ donators, and the reason behind this is they don't have any special treatment to organ donors, or nothing policy is in that sort. But what they have done is, by default, everybody who is above 18 is an organ donor, and if you don't want to donate your organs, you have to go to the municipal body and you have to fill out certain forms. So in that, because everybody thinks that it is such a lengthy task, they avoid filling out, and due to that reason, there is a high number of organ donation in India, and that, I believe, is a beautiful example of a successful policy design. And I believe the same can be implemented here, that if certain think tanks or certain SITs are organized for the same, I think that might lead to a better legislation.
What do you think, like what will be the effect on conviction rate of this act?
So, I think it's a clear answer that the conviction rate will definitely increase after the criminal identification has come about.
What important thing you want to present out of your presentation? One thing that it has to be considered while making any reforms in this sector.
So transparency of the data that's being handled here.
Okay, which is ideal model for this? Any ideal model you can suggest for?
Sir, I don't have anything specific in my mind right now, any specific model that I can present.
Any country's model that you can recommend, like this is the right?
India, prior to criminal identification bill, in itself was a great example of how the data was before the criminal identification bill. Was a decent example. I won't say the great example or the best example, but I think before the act, how things were could have been taken into consideration. Thank you so much, sir.
The next presenter will be presenting online. It's Mr. Shailesh Kumar Pandey and Mr. Akash Manwani.
Thank you very much. Very good afternoon to one and all. Shall I start, sir?
Please start.
Very good afternoon to all. I, the co-author for the paper, Akash Manwani, along with the author of the paper, Shailesh Kumar Pandey, we are going to present the topic on, we are going to present a paper on the topic of protection of the criminal identification data, comparative analysis between law in India and US. So privacy has emerged as one of the most important rights in recent time. And it's not merely a right, but it's about protecting the identity of a person. And that's why it's become so important to protect this. Now, there is a question that whether this right can override a law of a public importance or the criminal justice system. So, this question comes to this question leads to us a conclusion that there shall be a balance between the protection of the society and protection of the individual's right, because these are the two facets of a coin. First of all, we need to understand what is the criminal data, identification data. Criminal, please next slide. Criminal identification data are very crucial because it contains the fingerprints, DNA samples, facial recognition, iris scans, and so on and so forth. The authorities collect this data in order to investigate and to identify the criminals. Now, these data must be safeguarded because any leakage of this data would cause the individual at glance. So, these data must be protected. Earlier, we had the right of the colonial legislation by the name of the Identification of Prisoners Act, which is now replaced with the Criminal Procedure Identification Act. This particular act being a matter of controversy because it is when we compare with the Article 20 Clause 3, it is some way or other contravening the Selvi versus State of Karnataka. If we consider it to the Justice case, Puttaswamy case, which talks about the proportionality test. The Act also failed to pass this test because it's not justified that the amount of total rights that it is violation of rights that is taking and what benefit, how it's benefiting the society. Now I wanted to hand over the author of this paper for the presentation.
Alright, so very good afternoon to one and all. This is Shailesh Kumar Pandey, and now I'll be taking this presentation in continuation. First of all, I want to highlight certain effective results that the United States of America has produced by strengthful and effective implementation of the criminal identification procedures. First of all, United States of America is one of the most developed nations and is very advanced in criminal identification. That's why I've chosen it. Over 10 billion records collected from 45 states of United States of America is currently in the repository of FBI. 81 million stored biometric IDs are there in the FBI repository that FBI uses to identify and detect the criminals. 1,70,000 search per day are being done or requested by the law enforcement agencies of different states as well as federal agencies of United States of America. 10 million total background checks have been done in previous year, regarding which the data is given under the FBI Yearbook of 2022. Now, presenting data was required because I actually wanted to show the real significance of criminal identification process that has been adopted amongst different nations of United States of America. Now, Federal Bureau of Investigation is the repository where the biometrics are being securely stored. And on the request of the state parties as well as the federal investigation agencies, FBI disseminates and is the leading agency to somehow, we can say, circulate the biometrics as per the request that is received from the requesting parties. Now, one landmark legislation, that is BIPA, Biometrics Information Privacy Act 2008, was somehow implemented by the state of Illinois. And right after that, many other states of US implemented the Biometrics Privacy Act. However, in India, we are still waiting for the first Data Protection Act, and we are heavily concerned about how the data that will be secured in form of biometrics in the NCRB repository will be protected. Now, some of the emerging legal concerns that recently emerged in USA were that they were using face detection technology and other modern form of the biometrics scanning. Now, what happened that while using face detection technology, the face detection technology was most appropriate in case of detecting white people faces, but it was often misleading and gave false conclusion while analyzing the black, or I'll not say black, I'll say the darker race faces, because of its some technical fault and some technical glitches. Actually, we cannot rely that much upon the technology, and even in Indian context, we have to take it into the consideration that technology can give us a way higher reliability because of the science, but it is not fail-proof, and we have to take it into the consideration. Now, moving to the findings and the conclusion of the study, biometrics utilization in USA has shown remarkable results. It has produced remarkable what you can say growth in investigation-related affairs, as well as the conviction rates are also very high, because once you get the DNA from the place of incidents, that DNA can be matched with the repository, or else if some person is arrested, they have very advanced system of matching this DNA and everything. Now, for Criminal Procedure Identification Act, we have applied it, we have implemented it, that's one thing, but we have to also look at the infrastructural needs and the challenges, that is adequate training of the personnel who are dealing into the provisions of this act. And in accordance with the provisions of this act, the policemen, the medical personnel who will be collecting the sample, all the biometrics machine that will be utilized to collect the data, the quality of the machine, greater accuracy can be shall be somehow taken into the consideration. Now, while concluding the privacy regime in USA, which is having one of the most criminal identification system, the privacy concerns are continuously increasing. State of
2 minutes remaining.
And certain other states already in 37. The state of New York and other states have already imposed a ban over use of face recognition technique, and they have restricted the use of biometrics by the state machineries. However, by corrective measures and enforcing best practices, we can ensure that the purpose of the data is not in the contravention with the Article 21 of India. Until and unless we get Data Protection Act, this will be the landmark challenge for the government to somehow deal with the privacy issues as well as
Please conclude your presentation.
I have concluded. Last line I want to say that we have to maintain a balance between the individual's right, whose biometrics are collected as a criminal, as well as we have to maintain balance between the victim's right, whose somehow right has been infringed by the criminal's criminal activity. So that's it. Thank you so much.
Thank you. We can begin with the Q&A session.
Okay. Okay, so my question is like US has database for everything. So what do you think, like what are the challenges in front of us that we don't have the databases and all? And second thing, how we are going to assure the security of our data?
Sir, first of all, the most fundamental challenge in the database system is that now the dark web threats are increasing. The Indian institutes are continuously under the attack by the international hacker groups as well as the hacker groups of our so-called neighborhood. So first of all, we have to secure the data so that in case of any attempt of data breach, valuable biometrics of these criminals are not getting shared. We have to create a strong firewall system, as well as we have to ensure that these particular data is not just kept at the hands of what you can say NCRP, but also some repository offline should be maintained for storage of data.
So what is your recommendation? Like the data in US is stored centrally, and in India the law enforcement is divided amongst the states. Okay, it's a state part. So what you will suggest, the data should be centrally managed or it should be given state-wise in India?
Sir, alright sir, in response to that question, sir, most fundamental challenge for Indian state is that we have not that much fund as compared to United States. We are a developing country and we have to also look towards these financial constraints. But in United States, average time for processing a fingerprint or these verification background check request is 5 minutes. But if we'll not develop a decentralized request processing system, data should be stored centrally, but a decentralized request processing can be, different centers can be established.
Thank you.
Thank you so much.
Thank you so much. We will move on to the next presenter. The next presenter is Vansh Ved.
Sharing the PPT in the meeting only. It's okay? I'll share it in the meeting. Is there a lag or something? One second. There seems to be a lag. I'm changing the slides, but they're not changing.
Make it full screen.
Yeah.
You should share entire screen.
I am actually sharing the entire screen. I don't know why it's not changing.
Okay, let's start with that.
Alright, so good afternoon everyone. Good afternoon sir, good afternoon ma'am. My name is Vansh and I'd like to introduce my paper titled Balancing the Scales of Privacy and Security in the Age of Surveillance. As sir you mentioned that that photography, when photography began in the 1890s, I'd like to mention that the very first challenges to privacy began in the 1890s. And with the development of technology, photography technologies shifted to video technologies, and eventually this moved on to profiling and surveillance in the public space. So the first part of the paper deals with an analysis of surveillance technology, surveillance projects and operations due to several purposes, and it deals with this question in the light of three main questions. The first of them being, what kind of surveillance are we really talking about? So the answer to that is, we are dealing with surveillance, both targeted surveillance as well as mass surveillance, and both of these in addition to the surveillance that is carried out using our personal data without our consent. So some examples of this surveillance are activities like location tracking, private message monitoring, interception technologies, search history tracking, and social media monitoring. So why are these surveillances necessary?
So this answer lies in a lot of statutes that we already have, like the Indian Telegraph Act, as well as the exception to Article 19 in the Constitution, which mentions situations like when the national security or security of the state is at stake, interception of criminal activity, maintenance of public order and peace, and friendly relations with foreign countries. These are the situations where it is undisputedly necessary for surveillance technologies to be involved to protect the nation from any threat to the following. And the final question in the first part is where the paper addresses the main issue or the main problem. And this is where the paper introduces a term known as claimed purposes, which is to explain situations where the purposes mentioned in the previous question, where these purposes do not match with the actual purposes for processing, and there seems to be a disparity between claimed and actual purposes for surveillance, which is apparent in the face of lack of transparent and ambiguous legislations. So about ambiguity, I'd like to mention that ambiguity in the language of legislations prescribing procedure and defining exceptions to it can allow the executive to skew the interpretation of vague terminologies in their favor in a way that aligns with their own agenda. So I'd like to quote a very famous legal scholar who commented on this very early in the process in his book Introduction to the Constitution. Dr. Durgadas Basu said that the very justification of putting limitations on the legislature by adopting a guarantee of fundamental rights is that the entire history of governance of the country has conclusively proved that the group of human beings constituting the majority in the legislative body are not always infallible, and that is why constitutional safeguards are necessary to permanently protect the individual from legislative tyranny. These rights that we're talking about are so intrinsic and core to the citizens of the country that an infallibility on the part of the people constituting the legislature and the executive cannot be easily presumed. And that is why he mentioned, in context of protecting the fundamental right of property, which at the time was being omitted from Part 3 of the Constitution, he mentioned at that time that if that was the case, if we could assume that the legislature was that infallible and innocent, then this would be a good argument to omit any fundamental right from Part 3. So the problem here is with projects like Pegasus and Aadhaar is not the fact that the state is employing surveillance operations and technologies to keep in check crime. We don't have a problem with that. We don't have a problem with Aadhaar collecting the database of the entire country to provide financial subsidy to its people in a correct way. That is not the problem. In cases like Aadhaar, the problem is when the most fundamental principles of privacy, such as informed consent, they are violated by compelling an entire population to consent for a sacrifice of every bit of their personal information. So you are basically compelling an entire nation to make that information privy to you and between them and the state, and that is the problem that we're addressing here. In this background, we got the Puttaswamy judgment in 2017, and it set out a lot of principles relating to the right of privacy. The first one and the main one being the right to privacy being recognized under the ambit of Article 21, that is the right to life and personal liberty. The principle that was recognized was that privacy is not an absolute right, and the fact that privacy could only be circumvented according to procedure established by law. The judgment also set out that the procedure established by law shall be fair, just and reasonable. Additionally, activities interfering with Article 21 shall meet the standard of necessity, proportionality and legitimate state interest. Now, I'd like to quote another judgment in the judgment related to the privacy jurisprudence in the country, Govind versus State of Madhya Pradesh, which mentioned that this exception of legitimate state interest had another terminology attached to it in reference when we're speaking of Article 21, and that was compelling state interest, which is in a way a stronger or a higher degree of standard applied to an exception as compared to Article 19, which is merely using the phraseology state interest. this exception used this case mentioned that compelling state interest was the standard to be used here, clearly regarding a higher standard to infringement of right to privacy. Now in this background and these principles, we have the famous Digital Personal Data Protection Bill of 2022, which has been introduced with close to 30 sections, most of which I believe are operating in ambiguity, and there is not a single mention of the word privacy in the entire act, and there are no privacy principles set in this new bill. So as hard as it is to keep aside that for a moment, this paper proposes a mechanism to bring surveillance activities within a privacy legislation. I'd like to explain this situation in terms of a principle of rule of law involved here. That is a very relevant principle that is applicable to this case. This principle states that the quest of a civilized democracy is to combine that level of liberty without which law is tyranny with that level of law without which liberty is license. And I think this describes the situation largely, that the liberty, that is right to privacy, is combined with law, and with such a law that prescribes a procedure to curtail it in situations where it is necessary, and at the same time there is the law that prescribes this procedure is combined with a limitation by mandating compliance with procedure established by law, succeeded by judicial review, hence putting a limit on tyranny itself. Sir, I'd like to ask for an extension of 2 or 3 minutes. Basically the solution proposed by this paper is in terms of giving all the 3 institutions of the government a responsibility in terms of privacy legislation and regulating surveillance. The first being the legislature being given the role of the responsibility of defining the scope of exemptions that may be claimed by the government, and this responsibility is not just limited to defining the scope, but also defining and mandating a review of all the activities conducted in this surveillance activities on a judicial floor. So once the scope of exemption is defined, we move to the definition of the prescription of a valid procedure, which should be the only constitutionally valid process through which the right to privacy can be encroached upon. Once this responsibility of the legislature is mentioned, we have the responsibility of the executive to comply with these procedures and report and submit a report as to these activities. This report can be of 2 categories. It can be ex ante and ex post facto. Ex ante is when they ask for an authorization from judicial bodies regarding the activities they're going to carry out, and this can be done in situations which are not related to an emergency. In situations which are calling for an emergency and an urgency, ex post facto judicial scrutiny can be applied, where they put a report on control. Okay, in this way, once judicial review is put in the process, there comes the responsibility of the judiciary to finally decide whether this judicial scrutiny is decided behind closed doors for the purposes of confidentiality or in the open public. They should ultimately decide whether a surveillance operation can be regarded as constitutional or not, in a way by measuring the standard applied to it using the procedure established by law by the legislature. Thank you.
Any questions from audience? Okay, how you see the right of privacy with right to forget?
So the right to forget arises from the right to privacy itself, and it is made an element of right to privacy for the purposes that a person's rights in the society that he is going to live in the future don't get curtailed for an action that he did in the past. and this is very important in terms of litigation, in terms of the cases that may be made against the person. So I personally faced during one of my internships, I faced a case where a person's right to be forgotten was pleaded by my senior, and that person was employed in a multinational corporate company. He had a case against him in the year 2013, and that case was dismissed. Yet his name was in the court records, and our writ petition mentioned exactly this, that because of that, any future employment that he faced had this question, they did their basic research and they found their name in the catalogs of courts. So this very right is important, so that the future actions and future employments of a person or future liberties of a person are not affected by the actions he did in the past, for which reasonable time has passed, or the fact that he was acquitted from the same.
Okay, how you see, like, what is the importance of this, like, to right to forget in this type of a data where everywhere we are storing, recording data? What do you think, like, what should be the approach of a government on this?
So in terms of monitoring criminal activity, I feel like it is perfectly viable for the government to justify this retention of data. But in terms of, as I said, in terms of where there has been an acquittal or a reasonable time has been passed, I think the government can create a law which can keep a mandate of doing away with that data which it has retained regarding a person in cases where there is an acquittal or reasonable time has passed, and there is and the person has faced that sentence. Okay, thank you, sir. Thank you.
Thank you so much. The next presenter is presenting online. It's Dr. Gajashree Bhodke and Dr. Varsha Deshmukh. The next presenter is Dr. Gajashree Bhodke and Dr. Varsha Deshmukh. Please start your presentation if you are present in the meeting. Okay, we'll move on to the next presenter. The next presenter is Sandeep Ranjan and Archita Jha. They are present offline. The next presenter is Ms. Swati Jajaria and Mr. Mohit Yadav. They are present online.
Good afternoon. I hope I am audible and visible.
Yes, ma'am.
Thank you. Good afternoon, Learning Chair Mr. Anu Deshmukh sir and Principal Discussant Advocate Pawan Trivedi sir. Today, I, Swati Jhajaria, student of Army Law College, Pune, is presenting the research paper the Criminal Procedure Identification Act 2022, a conflict between the right to privacy and law enforcement, co-authored with Mr. Mohit Yadav. So, this paper is about what the Act provides for, how it raises concerns on the right to privacy, and how these concerns can be balanced with the law enforcement. Law is a reflection of society. Therefore, with the advancements and development in the technologies that has been enacted with the objective to use these developments for taking measurements for identification, investigation, and preserve records for future use. The police officers and prison officers are empowered to collect measurements of convicts and other persons as provided for under Section 3 and Section 5 of the Act. The measurements include finger impression, palm impression, footprint impression, photographs, iris and retina scan, physical biological samples and their analysis, and behavioral attributes. The Act under Section 8 empowers central government and state government to make rules for the enforcement of the Act, and the state government and the Union Territory Administration are empowered to establish agencies for collecting, preserving, and sharing the measurements under Section 4, subsection 3 of the Act. The NCRB, National Crime Records Bureau, a non-statutory body, has been made regulator under Section 4, subsection 1 to collect, store, preserve, process, share, and destroy measurements, and to provide for the standard operating procedures for the same. The right to privacy, which is an intrinsic part of the right to life and personal liberty, has been ruled to be protected as fundamental right by the 9-judge bench in the case of K.S. Puttaswamy versus Union of India in the year of 2017. The Act of 2022 raised serious concerns on this very basic right. Firstly, there exists ambiguity in the Act as the term like biological samples in the definition of measurements under Section 2B is not defined, and the term is broad enough to include narcoanalysis, brain mapping, which can't be taken without the consent and free will, as ruled in the line of judgment of Selvi versus State of Karnataka. Secondly, the NCRB, which is the regulator under the Act, was established by a resolution of Ministry of Home Affairs in the year of 1986 and is therefore not a statutory body, and it also lacks the expertise which are required for the performances of the functions entrusted upon the NCRB under the Act. Thirdly, the measurements once taken can be stored for 75 years from the date of its collection, even if the purpose for which the particular measurement or sample has been taken was fulfilled. And there is absolutely no reason provided for the same. Lastly, there are absolutely no safeguards available in the case there is a misuse of the sensitive information of data subjects or there is an infringement of the right of data subjects. The Act is essential to establish a robust mechanism of investigation and detection for national security. But the critical point in here is the coexistence of privacy and the security interest of society at large. And the balance of these two rights is very crucial for the effective implementation of this Act. The Act is protected as a reasonable restriction to the rights of the data subject in the interest of society, which would act as deterrence to the crime, because the data subjects would be under fear that they would be caught if they commit any offense in future. And the Act also provides for the destruction of the measurements if the data subject is released or discharged or acquitted by the court after exhausting all legal remedies, which is provided under Section 4, subsection 2 of the Act. There are some suggestions from the authors through which the desired balance can be achieved so that the mechanism provided under the Act can be effectively implemented. On this slide, the whole process has been shown from the collection of the measurements of the data subject to its destruction, and through this process, there are some suggestions for each stage for achieving the guidance. Firstly, the term biological samples provided in the definition of measurements must be defined so as to what all it includes, and it must specify that in what situation a particular sample can be collected. Secondly, the collection of measurement must be in line with the doctrine of proportionality, as was also ruled in the landmark judgment of K.S. Puttaswamy versus Union of India. The collection of measurements must be to the extent of what is necessary to fulfill the purpose for which it has been collected. And the collection of any other measurement or sample must not be beyond what is necessary. The processing of data must be as per the requirement of the case. For example, for identification, the finger impression of only one finger can be sufficient. But for the purpose of investigation, the finger impression of more than one finger can be required. Thirdly, the security of data must be maintained from the collection of the measurements to the final stage of destruction of the measurements. And this can be achieved by storing information in encrypted form and conducting data protection impact assessment to detect potential risk. And through data protection impact assessment, the authorities would be able to come up with a mechanism which is effective and risk resistant. The storage of data must be such so that the accuracy and integrity of data is maintained, and the period of 75 years for which the data can be retained as per the provisions of the Act must be reduced, and the future uses for which it is provided to be stored even after the purpose has been fulfilled must be provided for what purposes it can be stored. Fourthly, the subsequent use of measurements and communication or sharing of measurements to other bodies must only be when it is specifically provided by the rules or when it is foreseen by the law. That such communication is in the interest of the subject or there is an imminent risk to the public order or security. Fifthly, the above mentioned aspects can be achieved if the regulator is made a statutory body. Unlike the NCRT, which is a non-statutory body, and such body must have expertise which are necessary for the performances of the function. Only then the data subject would feel that their information is secure. Lastly, for the establishment of the safeguards against any misuse of the data must be provided. An independent supervisory authority can be created which would be responsible for ensuring and overseeing the compliance of the rules and regulations, and the legislation must provide for a framework on which the rules can be made. And such framework must ensure that there exist some safeguards, and there are safeguards in the mechanism which are provided by the Act in case there is any misuse or breach of any of the rights of the data subjects. And the data subject must also have a right to access information so that they are known that what are their rights and how those rights can be enforced. I would say that privacy is a fundamental and inalienable human right. So too is the security of a person. And the fundamental challenge in the implementation of this Act is to devise a mechanism which both these rights don't only coexist but flourish. With the advancements and developments in the technologies, the danger of breach of one's rights has been more than ever. In such a time, the implementation and execution of such an act, which can be easily misused, should be founded on strict rules and regulations with a mechanism of dispute redressal. Thank you.
Thank you. Any questions from audience? Okay. So I would like to ask you a question. What are the challenges in preservation of a biological data?
Right, sir. So the challenges would be that the particular information which is stored, it can be misused. It depends on which authority is storing the data and which people are working for storing the data. And it also depends that if there is a mechanism, if there is a misuse of data, how it would be treated. There must be some responsibility and liability of the person, of the authority which is storing data if there is a misuse of the data.
And what you think, what are the challenges while destroying the data also?
Sorry sir, can you repeat the question?
What are the challenges while destroying the data, biological data?
While sharing the data, right sir?
Destroying the data. So there is a provision to destroy the data also, right? Okay, what?
Period of 75 years, which is provided in the Act, is very long time, and
Please continue.
Sorry, sir. Am I audible now? Yes. So the period provided in the act is very long, that for 75 years, the data can be recorded. And once 75 years have elapsed, one must be vigilant that such data has to be destroyed. And there could be possibility that after 75 years, the data subject might be died because of the age and which the data was collected. So if data subject is never destructed from the repository where it was stored.
Okay, thank you. Thank you.
Thank you so much. The next presenter is Dr. Rakesh Chandra.
Am I audible?
Yes, sir.
Good afternoon, honorable chair and the presenter and the audience present there. My name is Thomas Mr. and presently I am only completed my PhD in law from the university. My topic is that balancing the role of technological surveillance against the right to privacy of Indian citizens. You know, as everyone knows that surveillance is an age-old practice. Previously, it was practiced in the form of manual surveillance and at the most telephone tapping. But during the last 2 decades, the technology have taken up the process of surveillance, and we term it as a technological surveillance. It is so much so that almost first of all, I will mention that I am talking about the state surveillance. So the state is using so many technological surveillance scheme using the advanced technology in the field of electronics intelligence. There are multiple schemes like CCTNS, NetGrid, NetCraft, EMS, TCI, and other schemes, so many schemes. So, but the worst thing is that all these schemes have not taken shape into legislative form. All the schemes have been brought in by the executive order, and there is no legislative sanction anywhere. Second thing is that under these schemes, there is no mention of the safeguards regarding the privacy of the citizens. And number three, there is no enforcement, either judicial or administrative. So all this, what will happen to all these schemes, this is, in fact, this is nobody, this only government is, or the state sector is knowing what they are doing. And their concerns are, and we have witnessed this concern in the crisis of Pegasus spy last year. Although the charges could not be substantiated in the Supreme Court, but the concerns are there because in that spyware, so many people from the civil society were removed. So there is always possible, especially when the government is strong or with an authoritarian outlook. This question arises, this question rather frightens as an independent citizen that what is going to happen. I agree that all these schemes which I have mentioned, the outcome of the counter-terrorism operations after the Bombay blast and our volatile situation in Kashmir and so on. But like the USA, there comprehensive patriot act. Everything what is done in the form of biometrics or in the form of surveillance, that is done through a legislative enactment. So everything is clear in the legislature, the enactment, what will be the procedure, what will be who will be the persons against whom this surveillance practice can be done, and the method of data protection. actually it is sorry that after 5 years of the privacy judgment, we could not produce any data protection law. And India is a country where there is no data protection law. Moreover, not only data protection, but how the data is protected in such a manner that no infiltration could take place in the data source. All these issues are basically technological issues, but there should be mention or there should be proper guidelines. One thing is that, one thing is here I want to remind you, all of you, that right to privacy is not an absolute rule. In X versus Hospital Z, the Supreme Court has said that where there is a compelling public interest, the right to be compromised. Similarly, under the Right to Information Act, it says that where the larger public interest, the situation, the information can be sort of. So where there is a compelling public interest, the larger public interest, the right to privacy can be diluted. But even then, balancing is the using most essential. First of all, there should be the provision should be enactment also, and the last thing is that who oversee that government is maintaining a balance or not. That work is to be done by an oversight. And oversight, the best oversight in the form of Parliament, where the annual report of this Ministry of Home Affairs, who is conducting all these schemes and different schemes under e-governance scheme. There are several ministries. All the the output, the reports, the activities will be taken before the Parliament, and only Parliament will oversee that the proper balancing is maintained or not. But unfortunately, this is not so. And whatever oversight is there, in case of this, that is available in case of telephone tapping, and that's all executive thing. Executive is sanctioning for telephone tapping, and executive is during the telephone tapping. So that was also using a scheme of things under the Data Protection Act. Data Protection Authority, that was also almost an executive body, although new Data Protection Act is coming, but in the bill of 218 or 19, the whole thing was in the hand of executive. So that is not there, and against the spirit of our constitution also, where separation of power doctrine is still very prevalent. So my extension is that things must be done by the government, that balancing of right to privacy and technical surveillance or state surveillance, it should be ensured at all costs. And that number two, it should be in the proper enactment. There should be proper enactment, one enactment or different or more than one enactment. It should be maintained the procedure, the due procedure, and the persons who may be brought under this umbrella provisions, and the punishment, etc. And number three, a proper and effective oversight is the key for maintaining right to privacy and other fundamental rights for the access. So all the things are lacking in our present system of government, and until that is done, we can't balance this both the rights and what is the power of modern technological economy. Everybody has seen in the case of vacancies in 5 years that till now hardly anybody knows how this was installed in the apparatus and how it works from the apparatus. So my emphasis will be that this is a high level, that balancing of the technical surveillance and privacy must ensure good of data. Thank you very much.
Thank you. Any questions from audience? Yes.
So my question would be that
Yeah, Mike. Just a second.
Hello.
Hello, sir.
Hello. Good afternoon.
Good afternoon. My question is related to something that which I also faced a difficulty finding answers to. Is that when we say judicial oversight to the thing you mentioned about oversight of these things that infringe privacy. So usually what happens is when a body is appointed, it is a specialized court which is appointed by the executive itself. The members of that specialized court are appointed by the executive itself, which is ex-judges or ex-members of the related industry. So how do we remove the involvement of the executive in the judicial procedure if we are talking about judicial oversight by these specialized courts?
As a matter of practice, what we have witnessed that whenever these oversight committees are appointed with involving the judicial appointments, there is always the concurrence of the acting Chief Justice of the High Court or the Supreme Court. So concurrence is priority taken of naming the judge of the High Court or the Supreme Court. So this is not the whole executive.
Okay, thank you, sir. Thank you.
Anyone? Okay, my question is, how will you see right of reputation regarding your topic, like in concern with your topic, technology surveillance and citizens' right?
Excuse me, sir?
Right of reputation.
Reputation?
Reputation. A person's reputations getting harmed during this surveillance and all. How you see that?
Actually, there is every possibility that person's reputation. This is true in the case of criminal investigation. Suppose there is CTMS scheme and there is a record of every criminal, whether he is confined for a smaller offence or the big offence, that is available at a thana level even. So in that locality, his reputation is always at stake. But that comes to the question of how can we protect our data so secure. So if there are proper to secure data, then this data will not be either hacked, could not be hacked by anyone or leaked by anyone inside the thana system. So this approach of data center is coming up. I think in the state-of-the-art technology data centers, when only 4 data centers are there, when there will be more, this problem can be solved.
Okay, thank you.
Thank you, sir.
Thank you so much, sir.
Thank you, sir. Thank you.
The next presenter is Harsha C.
It's not proper. Yeah, my topic is media trial and privacy concern with regards to Criminal Procedure Identification Act. As we know, 3 pillars of Indian Constitution is legislative, executive and judiciary. Even media is considered as the 4th pillar of the constituency. The legislative who formed the act has not specifically mentioned about privacy, but it is the other organs of the constituent to maintain privacy and not interfere in others' proceedings. In media trial, the media publishes the data of crucial criminal or any proceedings in their channel or in their websites, and then it will be infringement of rights. Mere collection of data is not infringement of right. As we know, even for other we had issue, but other has become a mandate now. And even if we consider the previous act of Criminal Procedure Identification Act, which is Identification of Prisoners Act 1920, it mainly focuses on collection of fingerprint and footprints. As Amol sir specifically mentioned that due to the technology changes and the developing world, even collecting so much of data is unable to get criminal punished or identify criminal. And my opinion on this act is that though this act does not specifically mention about privacy or anything, this act is backed up by Code of Criminal Procedure Act 1973 and Indian Penal Code. And collection of data is not infringing any fundamental right of anyone, because it is very useful for identifying criminals, or even in certain cases victim is unidentified because of the grievous nature of the crime, and it is very useful to identify even victim in such cases, and it will be very helpful for police or investigating agencies like CBI for smooth proceeding of investigation. And media and the act. In case of Y.V. Hanmanta Rao versus K.R. Pattabhiram and another, court held that when a litigation is ongoing, then media cannot publish even if it is verified truth. So in this thing, the government authorities have been very particular about collecting data, because there is very much of increasing crime modes. Like it can be digital, it can be physical, or it can be in any way, and we can't particularly identify the crime without prior collection of data. And legal provisions, as many of the presenters told that it is violative of privacy, but in my opinion the act is not violative of right to privacy, as the act specifically mentions about deleting of records after the acquittal of the prisoner, or after 75 years of the collecting of records. And right to information vis-a-vis right to privacy. As we know, right to information is important and right to privacy is also important, but for smooth running of the government and investigating agency, right to privacy can be infringed to certain extent, and right to fundamental right to reputation. Keeping in the mind of reputation of the prisoner or accused, the government has specifically mentioned deletion of records, and it is not publishing the data in any of the database in websites such as USA is publishing the records of their criminals. And criticism of this act is that this act should have been enforceable independently, but due to certain reasons it is enforceable only with the help of Indian Penal Code or Code of Criminal Procedure Act or any such act, which specifically deals about criminal crimes. That it is not violative of rights as information is taken with consent. No one is compelled or forced to give information as stated in State of Mumbai versus Katiogan. The case mentions that if you are compelling any person, then the information will not be valid in the proceeding. But if you are taking the information with consent, the information is valid in court proceedings. And the Act collects data for crime investigation and identification. And this does not specifically give any guidelines because it is up to the court and the executive to make such guidelines according to the situation of the society. And even deletion of storing of data should be managed by the executive and judiciary. And suggestions. The Act must provide guidelines for such collection and deletion of records because people may be afraid of their collection records being misused, such as the society when Aadhaar was implemented. People were scared that if their fingerprints or their data might be leaked or misused, but it is being mandated now by government for many identification purpose and everyone is fine. And for the betterment of judiciary and crime identification, prisoners or accused might have to give certain records other than normal people. If prisoners are subjected to normal people, they might not be getting justice or punishment as per the judiciary, and it is not feasible for anyone to collect such minimal data from prisoners. So there can be an exception. And government must bring awareness programs for usage and deletion of such data because people will feel that the content is dangerous and they may give anyone who pretend to be a government official or anyone might collect data. People might be afraid and not even give to government official for certain identification. Thank you.
Thank you. Any questions from audience? Okay. You know, in the previous act of prisoner identification, they used to take fingerprint. Okay. Now in this criminal procedure identification act, now they are taking an entire palm print. How this is going to benefit investigating agencies?
Sir, as we know, as the technology is growing and there might be any chances of even palm might be placed on any substance or anything. Criminals might be careful about their fingerprints and might leave their palm print or any other prints which are collectible by forensic department. So when government officials collect this data, it will be useful for them to identify the criminal and not specifically find for fingerprints.
Okay. So media trial is one challenge. We are aware, all of we are aware. But how you see the fake news thing also in relation with your paper?
As the inaugural chief guest Trivedi sir mentioned, a lawyer should not accept anything as it is. We should question everything. And media is such thing. People may follow news for general knowledge, but such news will be circulating via media which general people may not be aware. But we as lawyers and other legal professionals, we need to be very careful, and we should cross-check the information, and then we should proceed with the confirmation.
Thank you.
Thank you so much. The next presenter is Alicia Kanungo. She's presenting online.
She's on
Ma'am, you're on mute.
Please unmute yourself.
this technical error of ours.
There is some technical issue. Till that time, you can present your paper. If you are fine, you can present. Yeah.
What?
Yeah, it will go well.
Do you want it?
It's fixed.
Fixed.
Miss Alicia, you can start with your presentation.
Ma'am, am I audible now?
Yes.
And if my lights are visible?
We can't see your presentation.
Ma'am, is it visible now?
No, ma'am. No, ma'am. Ma'am, it's not visible. Can you present it again?
Then I'm sharing the slide and I'm doing technical issues about this not visible.
Ma'am, it's not an issue from our side.
Ma'am, is it visible?
Yes, yes, it's visible now.
Good afternoon. Ma'am, is it clearly visible? Or I am not able to see the slides. Actually, I will do due to some technical problem or what. I am not able to see the slides actually. Are you able to see?
Yes,
clearly?
yes. Ma'am, we're able to see and your voice and your video is also clear.
Oh, okay, thank
Thank
you.
you.
Good afternoon, everyone. Sorry for the delay. Today I'm going to present on the role importance of forensic science in victim compensation. Here I want to create a link between forensic science and victim compensation. So just some fundamental things here I want to tell you that forensic science is basically it's an act. It acts as a facilitator in crime investigation. So forensic science practically helps the court in the legal proceeding. It assists in collecting evidence, which is the key of the criminal justice system. Scientifically, it collects the evidence and find out the truthfulness of the fact in order to prove the accused guilt or innocent. And once the accused is proved to be guilty, then he gets conviction. So when conviction happens, the victim is entitled to get compensation as per section 357 of the Criminal Procedure Code. This talks about compensation to the victims at the time of conviction, which is to be given to the victim from the accused. So forensic science and compensation can only happen if the evidences are collected properly and it has been tested scientifically, it has been examined very well, then there is chance of conviction in case of in a criminal case. So we can say that victim compensation and forensic science, they are directly related to each other. It plays a vital role in victim compensation actually. So when you talk about compensation to victims under section 357A of CRPC, it talks about something different, like the other stakeholder who is the district legal service authority, it disburses the amount to the victim. But when compensation is given under section 357, it is given from the accused, and it completely depends upon the evidence that is given to the court, and the judge, depending upon the evidence, it gives the judgment in accordance to the fact of the case. And in this area, forensic science actually plays a very dominant role. So due to the scientific method and tools used in forensic evidence, there is undoubtedly a little place or bias or unfairness in this matter. So forensic science examines the evidence directly collected from the crime scene, and it helps in identifying the criminal to various themes, which includes fingerprints, footsteps, blood stains, hair samples, anything. So if I talk about is my slides moving?
Yes, they are.
So if I talk about the entire platform of the presentation, then I have basically in short picture type, I'll be presenting on the legal provisions regarding the forensic science. What is the judicial frame? What is the legal framework that is there? The legislative framework in relation to forensic science. And then I will be talking about the judicial trend as to forensic science. Then I will show you statistics where I have collected that there is restrictive use of forensic evidence in India, and I will be discussing about what are the loopholes and the shortcomings of forensic science, why there is so much of restriction in using the forensic evidence in the Indian criminal justice system. And lastly, what is the impact of forensic science, forensic evidence on victim offenses? I'll make a link between that. So if I talk about the let's come to the legislative framework regarding forensic science. So the there is a legal provision as to admissibility of forensic expert evidence is there under Indian Evidence Act. The Indian Evidence Act contains provisions regarding the acceptability of testimony from experts in the course of trial that is given under section 45 of Indian Evidence Act. This clause says the court can also ask any person to render advice who is expert in fields like identifying handwritings, finger impressions, laws, commerce, etc. to establish the court's own opinion. Expert testimony is essentially advisory in nature. We cannot say that the forensic science always, the result that forensic science gives is always final. It acts as an advice, it gives an advice to the court. So, section 45 and 46 of Indian Evidence Act deals with forensic science, and then section 293 of CRPC says in the process of any investigation, trial or other procedures, specified government scientific expert examination reports may be used in accordance with section 293 of CRPC. So the findings and conclusions of professionals are taken into account as supporting evidence in legal proceedings. And the court must determine whether the examinations were carried out correctly with sufficient caution and care, and subsequently whether they are done in line with the legislation or not. So, in the Evidence Act talks about, there is provision about forensic science in Indian Evidence Act, and at the same time there is provision about forensic science in Code of Criminal Procedure also. And also there was an amendment in 2005 which the scope of this amendment, the evaluation was increased to include the examination of blood stains, swabs in case of sexual offences. However, the amendment that happened in the year 2005 is specifically related to rape victims, but there is provision with regard to forensic science in Code of Criminal Procedure. So if I talk about the judicial trend as to forensic evidence, we can conclude that
various cases, if it has been analyzed, then it can be concluded that the courts in some cases have given positive response to forensic science, and in some cases the court has also ordered the investigating team to conduct investigation scientifically. I can say an example, there are several cases. On one case I can share, in Dinesh Dalmia versus State of Madras, High Court said that exposing an accused to narcoanalysis doesn't amount to collecting testimony using compulsion. So in this case, the court has given its own opinion that if any kind of compulsion is not applied on the accused or the person who is to be sent for forensic or scientific evidence to be examined scientifically, then it is not said to be a violation of Article 20 of Indian Constitution. So there are also other cases where the court has given recognition to forensic evidences. But despite of the fact of the recognition of the court and there is strong statutory legislation in connection to forensic science, there are existing shortcomings of forensic scientists. So if we see in 2021 also, the number of cases, most of the cases which come to a conclusion without seeking the help of the forensic science, courts are using the traditional method of to investigate a crime. The police is using the traditional method to investigate the crime, and the courts are also accepting the same investigation report just because due to certain shortcomings which are.
Please conclude.
Yes. So the workforce resources, there are only, we can say, roughly 3,000 experts or scientists out of 4,500 forensic workers employed by Indian forensic laboratories. The remaining staff members are just assistant employees. So there is lack of workforce resources. So most of the cases remain pending, which is why courts do not prefer to send a matter to forensic science laboratories. And another issue that I could say that forensic science education in India, there are approximately 80 institutions, if you see the data, that provide forensic science, which includes there are around 50 to 55 private universities and 20 universities are government owned. And so it's challenging for such institutions to offer instruction and specialization in all forensic sciences because due to the lack of forensic educational system. Next is legal provision. It is necessarily it is urgent to adopt a DNA bill that has been on the table for a long time in order to give legal protection to forensic science in India. Additionally, the Forensic Regulatory and Development Authority bill must be passed for India to have legislative framework for forensics.
We're really running out of time and your time is up.
Okay, so I'm just coming to the conclusion part.
It is the discretion of the chair and...
Okay, please conclude in 1 minute. Please conclude.
Yes. Sir, I would conclude that if the courts will adopt the scientific method if the courts will adopt the forensic science into its criminal justice system, then there will be more chance of conviction, because we have seen that the conviction rate is very low in India just because of the fact that they are using the traditional method of evidence and not using any kind of scientifically they are not accepting the evidence. So if scientifically it will be accepted, the number of conviction will be up, and at the same time it will directly or indirectly give some amount of benefit to the victim by rendering some additional compensation to the victim. So forensic science and victim compensation is directly related.
Thank you. Any questions from audience? Okay, just a quick question. which technique you will highlight, like which are the important technique you think which has been useful for victim compensation?
So, DNA testing is also one of the techniques that I would suggest, and also fingerprints, all of that.
Okay, DNA and fingerprint. Any other techniques?
So, in case of rape victim, then the swab, semen, etc. all these are essential.
Acha. What is the accuracy rate of DNA technique in such cases?
DNA testing, actually, if I see the data, then in 2021, almost 6 to 8% of the cases have been resolved through DNA testing.
Okay, and what about fingerprints?
Fingerprints, it is also similarly, I do not know the exact percentage, but it is also one DNA.
Okay, thank you so much. Thank you.
Thanks.
Thank you so much, ma'am. The next presenters are Mr. Harsh Srivastav and Mr. Kailash Jain. They are presenting online. Okay. So the next presenter is Mr. Yashwant.
Ma'am, am I visible and audible?
Yes, sir.
I will be presenting this. Yes. Ma'am, is my screen visible?
Yes, sir.
Good afternoon, everyone. This is Yashwant, a BBLLB student from Fairfield Institute of Management and Technology, Guru Gobind Singh Indraprasth University, Delhi. And I will be presenting upon my presentation on my research paper on the topic ethical issues in the use of technology in the criminal justice system. The subheads that I will be covering today, or the research paper that the subhead the research paper covers, is the inception and the IT Act working and the current laws working in India, GDPR versus PDPP, and the core of the paper talks about the Criminal Procedure Identification Act 2022. So the foundation of the right to privacy, firstly inception and the IT Act, the foundation of the right to privacy was as a fundamental right. It was laid down by a judgment of the Honorable Supreme Court in the case K.S. Muthuswamy versus the Union of India and others in the year 2017. Later on, a bill was drafted called Personal Data Protection Bill under Justice B.N. Committee, and which was further on introduced in the Lok Sabha on December 11, 2019 by the Minister of Electronics and Information Technology, Mr. Ravi Shankar Prasad, and the bill is currently still pending in the Parliament. The IT Act, what the IT Act has to say about data protection is that Section 43A mandates the protection of sensitive personal data and deals with legal weapons to fight data breach. And Section 72A imposes penalties on those who disclose sensitive information. Other than that, Section 20 of the Credit Information Companies Regulation Act 2005 also says that credit bureaus are required to develop a set of privacy principles. And the Aadhaar Act obviously prohibits the sharing of biometric information. Therefore, the personal data, the Aadhaar Act prohibits the sharing of biometric information and mandates the other identification information to be shared and used only for certain purposes, governs how the data gathered from the Aadhaar program is used. Next up we have GDPR versus PDPP. Basically, GDPR requires, the major differences are that GDPR requires the information guardian to share the names and classifications of the different beneficiaries of individuals' information with the information had, and in the Indian law it is not mandatory. The information for trustee will have to share the information if it is not gathered from him or her, whereas in Indian law the information trustee does not have to share any such information. The GDPR necessitates that the information subject is given a duplicate of information experience handling, whereas in Indian enactment orders a rundown of that information to be shared with no meaning of such that of what the synopsis is. Other than that, the main thrust of the paper, the Criminal Procedure Identification Act 2022 talks about that this law is a super law to the Identification of Prisoners Act 1920, and the only law in India up till now that permitted police to compile basic identification information that was an act of the British era. The requirements of the 1920 legislation were judged insufficient due to technological advancements and necessity for scientific investigations of crime and criminal law, such as the detailed and convicted persons' fingerprint and footprints. So the new bill authorizes the collection of and analysis of biological samples, including blood, semen, hair, as well as other features like the handwriting, signature samples, and other samples of DNA profiling, in addition to what was allowed under the previous legislation. Now, any person who has been detained or found guilty may provide the samples, even those who are arrested for crimes against women and children or crimes that carry a 7-year or longer sentence may have a biological sample collected forcefully. Additionally, a magistrate will now have the authority to approve the collections in accordance with the new bill. In addition to the previously mentioned authorities, the head warden of a prison and a head constable are also given the authority to direct the collection of the sample in order to maintain the record. The National Crime Bureau Records Bureau will serve as a central organization and will share the data with the law enforcement agencies. The gathered information will be stored digitally or electronically for long 17 years. If a person is freed without a trial or is found not guilty after a trial, records will be erased. However, after stating that reasoning in writing, a court or magistrate may order the retention of detail in such circumstances. Now, by including broad terms like physical and biological samples, the legislature may have intended the word measurement to be exclusive in nature. However, this could result in narco-analysis and brain mapping using force implicit in collection, directly violating Articles 20+3, the right against self-incrimination, and Article 21, the right to life of the Indian Constitution. No one accused of a crime may be made to testify against themselves as stated in Article 20 Clause 3 of the Indian Constitution. It has grown to be a subject of worry since people's privacy is in actual danger. Now the court outlined guidelines that need to be guided by legislation restricting this privilege. Now problem arises from the following factors. Data can be collected from anyone, not just those who have been convicted for a crime, but also those who have been arrested for any offence, from anyone else to help with an investigation. Now data collected does not need to be related to the evidence needed for the case. And the third, that data is stored in a central database that can be accessed by many people, not just those who have the access to the case files. Other than that, in contrast to the Law Commission 1980 stated that the 1920 Act was found in the idea that the more restrictions placed on the use of coercive means, the less severe the violation should be. Keeping in mind the DNA Technology Regulation Bill 2019 waives the need of permission of collection of DNA anyway. It should be highlighted that it also violates the criteria of human rights as it mentioned in the United Nations Charter, and the Supreme Court has ruled a series of cases dating back to K. Gopalan versus State of Madras, Khadak Singh versus State of UP, Charles Sobrag versus Superintendent Central Jail, Sheila Barse versus State of Maharashtra, and Pramod Kumar Gupta Saxena versus Union of India, that addresses various aspects of privacy, including privacy of space, privacy of body, privacy of information, and privacy of choice. Additionally, as noted by the Supreme Court in KS Swamy versus Union of India, Clause 4, Subclause 2 of the bill permits the retention of measurement records for 75 years, a clear violation of right to be forgotten. The bill permits the data to be stored for 75 years. Not only that, only when a person accused of a crime is ultimately cleared of all charges or released from custody will the data be destroyed. It is also possible that data storage in a central database and the future use in criminal investigation won't adhere to the necessity and proportionality requirements. Furthermore, the court ruled in Narayan that Tiwari versus Rohit Shekhar that no one should ever be forced to undergo any of the techniques in question, not even when they are being as a part of a criminal investigation. Such actions would amount to unjustified violation of people's personal freedom. Furthermore, it goes against the fundamental tenet of criminal law, which states that the person is innocent until or unless proven guilty. At last, I will just quote a judgment which says that judgment of the Supreme Court, which held that in a state of Andhra Pradesh versus Challa Ramakrishna Reddy, that the right to life is one of the fundamental human rights which is guaranteed to everyone. No one, not even government, has the right to violate something so fundamental. As a person still has humanity, even they are imprisoned. The person has humanity even if they are imprisoned. He still has a status of a human being, which entitles him to all fundamental rights, including the right to life, which includes right to privacy. Thank you.
Thank you, Yash. Does anybody have questions?
Hello. Yash, you were saying that this data collected by the agencies would be available to all. At one point you said, is it really the case that the data is available to all?
Sir, to be specific, I said that the data will be not accessible. Sir, I said not. It will be available to not. I did not say to all. Sir, I said it will be accessible to more people as required. Whereas in the current, in the earlier scenarios, the data would have been only restricted to the investigating team. Now, as the central authority has been designated the power to collect the data, it will be accessible to more people other than the investigation team itself.
And about right to be forgotten, you were saying that this data kind of proliferation would amount to violation of right to be forgotten. But are you equating that elimination of data is equal to elimination of this right to be forgotten?
So the elimination of data, so said here, is after 75 years. If the person is convicted. Other than that, sir, if the particular principle, the right to forgotten, has been given to everybody, and for a person who has not even committed a crime, right to forgotten comes later. First comes is what is actually done. According to me, sir, the right to forgotten, if a person who is not convicted and the case stretches to a time of a long 10 years or 12 years, then the person's reputation would be damaged for his whole life, no matter what, on ground reality, no matter what right to forgotten has been given to him.
Thank you so much, sir.
Thank you.
The next presenter is Mr. Harish Yadav. He is present online.
Good afternoon, sir.
Good.
I'm audible?
Yes, you are.
Yes, sir, you are audible.
It's
So are you presenting your PowerPoint presentation? So are you in the meeting?
Go ahead. Next period.
Yeah. Next presenter, Ms. Tanvi Thakkar.
Hi, good evening everyone. My name is Tanvi Thakkar and I'm my paper is co-authored along with Ms. Pratima Lokhande ma'am, who is Associate Professor at Nagpur University, and I'm a research scholar at the Nagpur University. So, coming straight to the topic, so we know the core topic of my subject is games. So we all know that games is an inherent part of our lives. Right from Mahabharata till today, we all play different kinds of games. In today's world, the gaming culture has changed, and nowadays we play games online, which includes games like Dream 11, Rummy Circle, and etc. So these games are none other than what are very broadly called as online games. So online games are nothing but games played through the medium of internet or played virtually. Now the question arises, behind these online games is a lot of user data which has been involved. So my topic is data protection and privacy in online game or legal appraisal. So with this we just start with the online gaming industry. The online gaming industry is likely to increase manifold in coming years. Due to pandemic, it has increased manifold. In fact, it is likely to increase by 3 million every year. So that is the average which has been estimated by a lot of firms and industry across. So that is the magnitude of online gaming industry. But behind all these gaming industry which has been growing manifold lies the user data. So when any user or a player goes to play game online, he adds in or he feeds in his data, his email ID, his phone number. To the extent he also feeds in his payment details. So what happens to all these data? Is the data which is being fed online safe? Is there a place where this is being stored? There is is the data which is being shared with these gaming companies, is this all safe? The answer is one and simple and straight. The answer is no. There is no clarity, there is no transparency as to where is the data being stored, where is it saved, where is it that it is protected. There is no clarity in either of the online gamings. They have come out with clarity around these particular aspects. So that is the problem area where the research of my entire paper lies. Coming to, is there any protection available around this? So in July 2022, the central government had taken steps and banned one online game which was Battleground Mobile India, which was found to breach data collected of its gamers. So that was a major step that was taken by the central government. Coming to the laws of other jurisdictions, so the first and the immediate one which comes around the protection of online gaming is the country of China. China has got a very strict and rigid laws around it. In fact, they have gone into prescribing provisions wherein they are saying that what should be the hours limited for children to play games in a particular day. So they have come out with rules and provisions where they have restricted the playing of online games for minors or for children. Next country or the other jurisdiction which we can refer to is the famous one, which is the GDPR, which comes from Europe. Again, in the GDPR provisions also, there are provisions which prescribe for protection of information being shared by the online or by the gaming industry. Apart from the GDPR, there is also US. US has not got one, but they've got multiple legislations or regulations protecting data of online gamers which are being shared while playing the games. So these covers the collection of data, is it data protection and in India and worldwide. Comes the data protection and online gaming provisions of data protection, the data protection bill. So in India, as we all know, there is right now there is no legislation which has been passed. However, there is a bill which has been prepared. So there is a privacy data protection bill. Now, privacy data protection bill has got provisions with respect to definitions of what is a sensitive data, personal data, and what is a critical personal data. It was also, the bill also has provisions with respect to cross-border flow of data. Now when it comes to online gaming, why is this of importance is because when a game is online, there can also be gamers participating from world or from different parts of the world. So what happens to that data when it is being transferred across borders? So that particular aspect is not being prescribed, but there is a lack in the existing bill. Second is also the bill currently prescribes of obtaining an explicit consent before obtaining a personal data. So what happens if when a person goes and plays these games of online, will there be a consent taken explicitly for every game, or will it be just a tick where a gamer, when he plays, he signs up online, first he logs in and creates his own user ID. It's just the one time. What will happen if the game is, he every time goes to play, will it be taken? So again, that is a grey area which has not been highlighted or not regulated as of yet. Third is the third major setback which is there under the present bill, of course it is still a bill, is what happens to the children who are playing these online games and the data which is being collected. Also what happens many a times when a gamer logs in, he says that I am older to 18 years, he ticks it, but we don't know virtually whether a person who is playing is actually a person who is of the age of 18 or is lower to the age of 18. So these are all the grey areas in the existing bill which exist. Coming next, so further government recently has, because of the current surge or increase in the gaming industry, just recently, few months ago, government has come out with a specific bill only for regulating the online gaming, which is the Online Gaming Regulation Bill of 2022. Now under this bill, there are provisions which government has prescribed. There is a major one which says that there will be a commission or a regulatory commission which will be set up for regulating the online games. Now, the gaming industry or the organizing industry who is making these games, they are supposed to obtain a license from the regulatory commission. However, though they have prescribed that a company has to go and obtain a license, they have not prescribed or they have not said anything about the data protection which will be collected by the gaming industry while they are organizing these games. So that the current bill is silent on that particular aspect. So as I said before, the gaming industry is booming like anything. It has been mentioned by the finance minister, Ms. Nirmala Sitharaman, in the current finance bill also. There is a very specific mention about the online gaming industry. However, it lacks these areas of data protection and the data, personal data which has been collected, huge data of gamers which has been collected. So that is an area which needs to be regulated. So suggestions, because it is not going to be that we cannot stop online gaming because that is the new culture which everyone is into. So that is not going to happen. So to suggest to have a curb on those will not be a practical solution. The only solution is to regulate it, and also while the gamers, it is also responsibility, equal responsibility lies with the gamers to have an online hygiene when they play. What does this include an online hygiene? Conclusion and suggestions. Yeah. So so the suggestion is also the gamers need to have a extra hygiene when they play these games. You have to ensure a double verification, share personal data only which is required, etc. So those are my conclusions and suggestions. Thank you. Any questions?
No, we're done. Thank you so much, everyone. The participants can wait here for the valedictory ceremony. The online participants can join the valedictory ceremony meeting link. The time for the same will be informed. The valedictory ceremony will start at 5 p.m.
Is he coming? Is he joining? Sir, wait, how are you doing?
Yes.
Good.
start the validatory. How did you change? I took one.
एक मिनट.
It's looking funny at the back of our head.
एक और भी also है. Which is like
Oh, the photos morning also of that you took the back. Now you will be putting some background na, in the validation. For that.
The PC is very slow.
PC is very slow.